Thank you. Presiding Officer, last week we asked about legal advice in the Alex Salmond case, and the First Minister refused to answer any questions. We were told that every issue had been covered. Then, the next day, after FMQs and 2 days after her evidence session, John Swinney released another tranche of legal advice, even more damning than the last. So I'm going to ask the questions that the committee couldn't, about the evidence that the government were so reluctant to release. This new evidence shows that the government's senior lawyer, Roddy Dunlop QC, warned the First Minister personally against, and I quote, ploughing on regardless, because of a large expenses bill that would inevitably rise. So let me ask the First Minister, how much taxpayers' money did it cost from that moment on?
First Minister.
We've set out the costs of the judicial review. I don't have that breakdown to hand. I can look in to see if we can provide that breakdown to Parliament. I think Ruth Davidson, in some respects, makes my point for me. And let me say, first of all, I take, whether the opposition always want to believe this or not, I take these matters extremely seriously. And I take very seriously the obligation on me and on my government to learn lessons from this. But the point I think Ruth Davidson is making for me is that she is quoting from the legal advice that has been published. We have published all of the substantive legal advice, which sets out very clearly, I can take the Parliament through exactly what we have published in response to the requests for that. But we have set out the substantive legal advice, and anybody who wants to read it, I suspect most people watching right now probably want to hear about vaccination and COVID and when we might come out of lockdown. But anybody who wants to read the legal advice can go onto the Scottish Government website and do that. And what that legal advice sets out very clearly, warts and all, it is an unvarnished account of what went wrong, are the opinions of senior counsel at different stages of the judicial review. It sets out very clearly the error that was made by the Scottish Government and the way in which that error became to be fully realised and understood. It also sets out the views of the law officers, and of course in terms of the ministerial code, that's what matters to ministers, well into December, that notwithstanding all of that, the government should continue to defend the case for the wider reasons that have been set out, and then later in December, the reasons why that was no longer possible. So I think the impression the opposition is perhaps trying to give, I think, is that what we've published is somehow a rosy picture here and there are horrors lurking underneath that are being concealed. Anybody who reads this can see very clearly that is not the case. A serious error was made by the government in this investigation, and as the judicial review proceeded, that error became very apparent, and that is why ultimately the judicial review had to be conceded. So perhaps instead of chasing phantoms, the opposition should focus on what is there, because it sets out very clearly the mistake the government made and the lessons the government needs to learn from that, and the lessons I am determined that the government will learn from that.
Ruth Davidson.
Presiding Officer, I asked the First Minister a very specific question, and whatever that was, it wasn't an answer. We have since learned that from the moment that Roddy Dunlop wrote that note on the 17th of December, to the time when the government finally conceded, the bill exceeded £100,000. Perhaps even £200,000, but we don't know for sure because the government won't tell us their side of the bill. Now, before the First Minister's committee session, we know that Queen's Counsel stated, and I quote, the least worst option was to concede the case. That was on the 6th of December 2018, a month before the case was finally collapsed. What we didn't know last week, and we only found out on Friday, was that the First Minister personally disputed this advice. And we know this because Leslie Evans sent a note that said that she and the First Minister were unclear about what has changed since the last notes in the First Ministerial meeting. Again, I'll put it to her, if she had conceded then, hundreds of thousands of pounds would have been saved. So why did the First Minister think that she was a better lawyer than Roddy Dunlop QC and the advocate Christine O'Neill?
First Minister.
I didn't, and I absolutely, most definitely don't. But what I do know is that it is my job as First Minister to ask questions, to query things when I don't fully understand what is being put before me, and to make sure I have as full as possible an understanding of the decisions that lie before me. And I actually think it would be more remarkable and more deserving of criticism if I didn't ask questions like the one that Ruth Davidson has just suggested that I did. But she talks about advice in an early part of December. One of the things that I was questioned about and talked about extensively before the committee last week was the summary from the law officers on the 11th of December, which sets out very clearly, and people can look at this, is that the view of the law officers then was that, taking account of everything, they believed we should continue to defend the case, that there were credible arguments, and I think that's a quote from the summary note on the 11th of December, across all of the points of the petition, including the appointment of the investigating officer, which was the key area of problem for us. And it was set out there that that was because there was a wider interest, as long as the case was stateable, in getting a judicial determination on the array of challenges that had been made both to the fundamentals of the procedure and the application of the procedure. So it's not that these issues weren't properly considered, and yes, judgments were made, but everybody can see the views of councils, the conclusions of law officers, that ministers are duty-bound to base our judgments and decisions on, and then what happened later in December that led to the decision to concede the judicial review. And of course, we also see a note from Council, I think as late as the 17th of December, where they say they believe the case is still stateable, albeit they have significant concerns about it. So, these are always judgments for ministers, taking account of a range of things. There was a mistake made by the government in the application of this procedure, as that became fully understood during the progress of the judicial review. That is what ultimately meant we couldn't defend the judicial review. But there were wider interests that we were also right to take into account and carefully consider at every stage of the process. And the point here is that people don't have to take my word for this. They can go and look at all of the material in quite unprecedented fashion that has now been published and draw their own conclusions, as indeed can, and I'm sure will, the committee in due course.
Ruth Davidson.
Thank you, Presiding Officer. The new evidence that was withheld from the committee until after Nicola Sturgeon appeared shows that Roddy Dunlop QC wrote back when the First Minister challenged his advice. And we now know what he told her in response. He wrote that there were two options, and I quote, "I doubt either will work." Then a week later, both senior lawyers said that their advice had been discounted. Roddy Dunlop is the current Dean of the Faculty of Advocates. He is the most senior lawyer in Scotland. And as he previously had explained to the First Minister, conceding the case early would reset the procedure and allow for a renewed investigation less open to challenge. So in effect, the women's claims could be looked at again, but with the Scottish Government doing it the right way, rather than spending all this time and money defending the indefensible in court and letting these women down all over again. Why didn't the First Minister listen to him?
We did listen to Council, but lots has been said rightly, and I'm not going to get into this because other people or another person is looking at this right now, but lots has been said about the Ministerial Code. Anybody who goes and reads the Ministerial Code will know that in terms of the obligations on ministers, the views of the law officers are what we are duty-bound to make sure we take into account. And I've just narrated the views of the law officers. Now, the law officers coming to the opinions and the judgments they do, of course, take account of the advice and the views of the council that government instructs, but take account of the wider interests of the government and the wider public interest as well. So we take account of all of this. And Ruth Davidson used a term there that is just not correct until a very late stage, to say we were defending the indefensible. Yes, council had mounting concerns. The case was considered to be stateable, even by Council, up until, I think, the 17th of December. And there were wider interests that the law officers thought were important to take into account. Now, a different First Minister may have reached different judgments. That is absolutely undeniable. But any First Minister in the job has to take the decisions based on the array of advice we have and weighing up the right things. Now, it is undeniably the case here that the government made mistakes, which we are determined to learn from. And part of that is to look at why we got into a position in a judicial review where it became indefensible and therefore we ceased to defend it. And the advice that Ruth Davidson is quoting from the latter part of December, that is the start of that process of the government realising it could no longer defend the judicial review and taking the appropriate steps to concede the judicial review at that point. So there's lots and lots and lots that I and the government have to reflect on here, and I am absolutely determined to do that. But the public have, if they so choose, the ability to read all of this for themselves. They will shortly have reports from the committee, I hope. They will shortly, I hope, have reports from James Hamilton into the issues with the ministerial code, and they will shortly, I hope, have the report that the government instructed from Laura Dunlop QC into some of the internal issues that we have to reflect on. So we are taking these issues really seriously and in unprecedented fashion. Unprecedented not just for this government, but in the lifetime of this Parliament, have put into the public domain information that allow the public to draw their own conclusions too.
And Ruth Davidson.
Presiding Officer, at her committee appearance, the First Minister became very forgetful, and she seems determined to forget that it was her government who were the ones who failed these women so badly. According to 5 people now, including a QC and a civil servant, her government is responsible for leaking a complainant's name to Salmond's team. But nobody's been sacked or even reprimanded. And despite all her protests, the flawed procedure, the one that let these women down, has never been changed. The First Minister just mentioned a second ago that 6 months ago, another QC, Laura Dunlop, started a review of the procedure. Our clear understanding is that Ms Dunlop has reported in writing back to the Scottish Government on her work. So for the sake of confidence in the procedures, will the First Minister publish it now? Because, and I don't say this lightly, this week has shown again that sexual harassment complainants cannot trust the ruling party to deal with a complaint properly.
First Minister.
Well, firstly, can I say the first allegation that Ruth Davidson made there is disputed, and I disputed it at committee last week. Obviously, I wasn't party to the conversation that it is based on, and I'm limited in what I can say because of legal reasons. But let's be clear, that is disputed. In terms of the procedure, the first thing to say is what was found to be flawed was the application of the procedure. The procedure itself may well have been found to be flawed had the judicial review proceeded, but it wasn't. But we obviously want to await the various inquiries before reflecting on changes we need to make. I've not seen Laura Dunlop's review. It will be published, and it will be published in early course once we have seen it. I want everything about this to be open and transparent because I do want to learn lessons. Ruth Davidson, perhaps belatedly over recent days, has started to talk about the women, and I welcome that because that is the issue right at the heart of this. I will be haunted for probably the rest of my life about the way in which the government, through an error made, I think, in good faith, but nevertheless an error that let down those women. I've apologised for that. I wasn't involved in the investigations. I wasn't aware of the error at the time, but as head of the Scottish Government, I take and I feel responsibility for that, which is why I think it is so important to cast aside the politics in this and actually focus on the substance. That's what I'm determined to do, and that includes a determination to learn any and every lesson that any one of these inquiries tells us that the Scottish Government needs to learn.
Thank you. Question number 2, Anas Sarwar.